Greg Steinman from McDermott, Will and Emery in New York.
Good afternoon, everyone.
That was selected. Michael Cordasco from FTI, which is the committee's financial advisor.
Good afternoon.
And then finally, Jason Raznick, who is the chairman of the creditors committee.
Good afternoon.
I'm glad that we finally have a chance to speak with you today in this forum, and I want to apologize for not having done so sooner. When a committee is appointed and selects its counsel, there's a lot of work that needs to be done in a compressed period of time, and that is what we have been focused on for the last few weeks. So again, thank you for your patience. I know that a lot of you are suffering. Many of you have invested your life savings in Voyager. All of you trusted Voyager, and all of you feel wrong. We hear you, and we share your sentiments. We have read your letters, your emails, and we have listened to your voicemails. We will do our best to respond to all of your questions throughout this case, but just please understand that there are over 100,000 of you who are owed money or crypto. And I hope that you appreciate that we are doing everything possible to protect the interests of the entire creditor body while also providing you with as much information as we can. For the first half of this town hall, we are going to provide you with an overview of the bankruptcy process generally. And as we do that, we'll explain how that process is playing out in this specific bankruptcy case so that all of you understand what is going on. I recognize that many of you just want answers to what may seem like basic questions, such as when are you going to get your crypto back? Unfortunately, there really are no easy answers in bankruptcy, and understanding what might happen in this case really requires an understanding of some general bankruptcy concepts. So we'll try to keep this as simple as possible and then move quickly toward the Q&A. Now, to be clear, this presentation is by no means an exhaustive explanation of the bankruptcy process, and it's important for each of you to understand that our firm, McDermott, only represents the creditors committee. We do not represent any individual creditors or customers. So unfortunately, we cannot provide legal advice to any of you individually, and nothing we say today should be construed as legal advice. Some of you may have unique circumstances, while many of you are likely in the same boat. Either way, you may want to retain your own counsel to represent you in this case to explain important concepts and advocate for your individual rights. And that is a decision that each of you needs to make. Our goal here is to help provide a general understanding of what's happening in the case, what the committee is working on, and where we are headed, and more importantly, how all of that impacts the most popular question that we received from you, which is when will you receive a distribution in this case and how much? The final administrative issue that I want to mention is that we are not able to disclose every piece of information that we have. I know that that may sound unfair, but for better or worse, this is how the process works. In exchange for Voyager providing us, the committee, with a significant amount of commercially sensitive and confidential information, the committee signed a confidentiality agreement with Voyager. And there are good reasons for that in this case and every other bankruptcy case where a committee is appointed. Just as an example, as many of you probably know, Voyager is currently running a marketing process to sell the company or its assets. If information regarding the identity of bidders and their bid structures became public, that could have a negative impact on the sale process, which is ultimately going to harm the creditor body, all of you. Now, although we can't share all confidential information with you, please know that the committee and its professionals are receiving access to a significant amount of information from Voyager that is needed for us to make important decisions that will be made throughout the case. We are not operating in the dark, and there is a lot going on behind the scenes. Some of you may be wondering why we haven't done certain things or why we have done certain things. We will do our best to be as transparent as possible with you throughout this case and explain why we are doing certain things. But there is some level of trust needed that the committee is doing what is best for all of you as a whole. And I hope that we're able to continue to build that trust with all of you through these town halls. Before we get to the presentation, I want to turn it over briefly to Jason Raznick for a few words. Again, Jason is the chairperson of the creditors committee.
Hi, thank you for listening to us and being here today. Obviously, we'd love to be doing this on different circumstances. I'm a creditor. I'm the chair of the credit committee. I had a lot of money in Voyager and was hurt, like many of you, who trusted Voyager with assets, some people, their life savings. I have heard from hundreds, maybe thousands of creditors through Twitter, through any mechanism that you've been in touch with me. This is an issue that hurts and affects us. A lot of us invested in Voyager as a place to put money in, like a savings account. And I know that, and we know that. And Darren and his team know that. Our goal is to get as much money back as quick as possible. I said when I joined this committee that I didn't really want to participate or be involved if that wasn't the shared goal. As a committee member, we don't get paid to be a committee member. It's actually taken probably hundreds and hundreds of hours, and I'm happy to do it because my goal, again, is twofold. Get as much money, get as much of your money back and as quick as possible. That doesn't necessarily what the outcome is. There's a lot of different scenarios, and I'm not going into that, and that's where the lawyers can talk. But I just wanted to talk on behalf of creditors. I know how challenging this situation this is, and everyone's situation is different, and everyone has different circumstances. I'll just share one small story. When some outside person thought we should delay this case until September, I freaked out along with the credit committee because their answer was that a lot of professionals are off in August and we should just, resume it in September. And I'm like, we don't have that time. People want access to their money. And how am I going to say to the person that called me that had $40,000 in for their life savings or for their wedding fund that we're going to take offers till September? So we are working around the clock to do the right thing. And some of the stuff may not make sense, but we're trying in every avenue to get as much money as possible in the shortest amount of time. And trust me, like, I didn't know getting into this kind of work that is involved, but it's, it's anxiety. It's working hard to do whatever we can. And I promise you, have some good teams at it. And I just wanted to speak up. You can find me on Twitter, but we're here and working along behind the scenes. Thank you for listening to me. And Darren, if there's anything else you want me to say, let me know, but that's kind of all I have.
Thanks, Jason. So with that, we'll start the presentation if we can put that up. All right, we can go ahead to slide 3. So another popular question that we received from many of you relates to how the committee was formed. Some of you expressed concern that the committee is acting at the direction of the company or that the committee is somehow under the influence of the company. I assure you that is not the case. When a large company files for bankruptcy, there are often thousands or even hundreds of thousands of unsecured creditors. The committee is formed to represent the interests of all of those unsecured creditors, and the committee plays a critical role in complex cases like this one. As you'll see throughout this presentation, the committee is not a passive party in this case, but rather is engaged deeply in all facets to ensure that unsecured creditors' interests are adequately protected. Creditor committees are formed by the Office of the United States Trustee, which is an arm of the United States Department of Justice. In this case, the U.S. trustee selected 7 members to sit on the Voyager Creditors Committee. All 7 members are customers of Voyager who are owed crypto. Their claims vary in terms of type of crypto and in terms of value. A few of them are owed millions of dollars worth of crypto, others less. So they have every incentive to do what is best for all creditors. To be clear, Voyager had nothing to do with the selection of the committee or the committee members, and the committee is entirely independent from the company. Like many of you, the 7 members who were selected submitted a questionnaire form to the United States Trustee's Office, and then the U.S. trustee made a decision about who to appoint. We had nothing to do with that process, nor did Voyager. After the committee was formed, their first task was to retain counsel to represent them in the case, as well as hiring a financial advisor. There are more than 10 law firms, including ours, that expressed interest in representing the committee. And after extensive interviews with the committee, they selected our firm, McDermott, Will and Emery. Again, Voyager had nothing to do with that process. The committee members and only the committee members made that determination by a vote after significant deliberation. And a similar process occurred when the committee retained FTI as its financial advisor. So to summarize, the committee is completely independent of Voyager. And although the committee's professionals do not represent any of you individually, the committee has a fiduciary obligation to the entire creditor body and must do what is in creditors' best interest throughout this case. I'm going to turn it over to Chuck now to discuss some of the more general bankruptcy concepts.
Thanks, Darren, and good afternoon again, everyone. I think the easiest way to start is just by an acknowledged fact, and that is that the Chapter 11 process can be a useful tool for insolvent companies. And to be clear, Voyager is insolvent, and we'll talk about in a few slides, or as we will, Voyager doesn't have enough crypto to satisfy all its customer claims. When a company files for Chapter 11, it can continue to operate its business with protection from the pursuit of creditors or plaintiffs. And it may seem a little antithetical to you to have a process where the people that drove the company into bankruptcy continue to remain in control of the company, but that is in fact the process. They are vested with the title of debtor in possession unless and until management is thrown out based upon proof of bad acts, for lack of a more complicated explanation. When the bankruptcy case is filed, an automatic stay is triggered, and that prevents individual creditors from pursuing remedies against Voyager while the case is proceeding or pending. Given, as I said, that Voyager does not have enough crypto to satisfy all your claims, this prevents a situation where some customers, get repaid in full while others receive nothing simply because some creditors were the first to make a withdrawal request. In short, one important goal of bankruptcy is to ensure the equal and fair treatment of all creditors. However, not all Chapter 11 cases result in a reorganized company that exits bankruptcy still in business. Many Chapter 11 cases are filed to pursue an orderly wind down and liquidation of the company, with all of its assets being thereafter distributed to creditors. In these liquidation cases, it's common for a liquidation trust to be formed, and that trust will have two primary goals. The trust will take transfer and title to all assets from the bankrupt company after the plan is confirmed, and ultimately will distribute all of those assets to creditors. Second, the trust takes title to all claims that the bankrupt company has against third parties, and they'll pursue those claims through litigation for the benefit of the creditors. Many of the litigation targets or potential targets in this case will be people and companies closely affiliated with Voyager. So it's common for the liquidation trust that's formed pursuant to a liquidation plan to be controlled by the creditors committee and its professionals in order to maintain complete independence from the company. And that's what we'll be seeking in this case. Regardless of whether Voyager seeks to reorganize or liquidate, it's common for a bankruptcy case to conclude with the confirmation of what's called a plan of reorganization. And we'll discuss this process and the contemplated timeline in just a few more slides. Let me turn now to a couple of process issues regarding a bankruptcy case. When a company files for Chapter 11, it cannot continue to make payments that it might owe on debts that were owed as of the day they filed bankruptcy without obtaining court authorization. For example, if prior to the bankruptcy filing, Voyager owed $1 million to its landlord, the company would not be able to pay that amount without court approval. Again, that's consistent with the goal to ensure that creditors are treated equally and fairly. Of course, there are a number of pre-petition debts that the company needs to pay in order to continue operating. So on the first day of the bankruptcy case, the company will typically file what we call first day motions. And given the majority of these are administrative in nature, and given the debtor's need to maintain operations, the motions are filed on an emergency basis. Generally, within 1 to 3 days after the case is filed, the court will hold a first day hearing at which it will grant necessary relief on an interim basis. During this period of time and between the interim hearing And the final hearing on the motions is when the committee is usually formed. And that's when our committee in this case was formed. And we, like committees in most cases, immediately had to begin to work around the clock to analyze the various first day motions that the debtor had filed and to determine whether or not we agreed with their business judgment and whether those motions and the relief they were seeking was appropriate. The Voyager in this case filed a number of first day motions shortly after commencing the case. And after we were appointed, we reviewed them all and we made a number of informal objections. Ultimately, the debtors agreed to the majority of our requested changes, which obviated the need for the committee to file formal objections. As Darren said at the outset, there's a lot that happens behind the scenes that does not show up on the bankruptcy court docket. One goal, or our goal, when possible, is to resolve issues consensually with Voyager, because we believe that will ultimately save the estate money. And to be clear, that money will be used to repay your claims. So when we are able to address the concerns that we have to our satisfaction without the need to litigate those issues in court, that is our preference because it's ultimately going to result in a savings to you. But trust us, if we can't, we will file objections to the relief that Voyager is requesting, and we will litigate aggressively on your behalf to try to get to a judicial determination resolving the dispute that gives us the relief we want. Let me pause there and maybe I think it's going back to you, Darren, for the next slide.
The next topic we want to cover is the sale process. Voyager is currently soliciting bids from interested parties to acquire some or all of the company or its assets. There are several different bid structures that can be used to acquire Voyager's assets or the company as a going concern. Many of you have probably seen one of the bids, which was made public by FTX, but I can tell you that FTX is not the only interested party. The company has received several indications of interest, as Voyager's counsel has said at the last court hearing, and formal bids will be due on August 26th in just about 2 weeks. The committee is actively involved in that sale process. The committee members have spoken directly with the business people and lawyers representing the interested parties and will continue to have those conversations. And importantly, the order that the court entered approving the bidding procedures for the sale process in this case, it provides the committee, us, with broad consultation rights throughout the whole process. Again, this is an area where we cannot disclose specific details, and I hope that everyone understands this is to protect your interests. The goal is to maximize value for all of you, the sale process, and disclosing who is bidding and in what amounts at this stage could impede that goal. Now, I know that some of you feel that the company should take the FTX deal and that they should take it immediately. What I can tell you is that as Voyager disclosed in open court at the last hearing, the FTX offer is actually the lowest of all the indications of interest received so far. And that is exactly why we run sale processes in bankruptcy, to make sure that the company and its assets are properly marketed to obtain the highest value for creditors, all of you. Having said that, we have worked with Voyager to create an incredibly accelerated timeline for this sale process, which we've illustrated on the bottom of this slide. By the end of this month, we should have a very good idea of who the winning bidder is and the terms of the sale. I see that some of you in the comments are asking for this deck. Both this video stream as well as the deck will be posted after we're finished here on our Twitter page as well as the committee website. So don't spend your time screenshotting. We're going to put it all up for you. I'm going to turn it over back to Chuck now to talk about the plan process in this case.
Thanks again, Darren. Before we talk about the plan process, we need to mention an important disclaimer, and it's there in bold type on slide 7. Nothing we say today during this town hall should be construed as a solicitation by the committee to vote in favor or vote against a plan. As we will discuss shortly, there's a specific process for soliciting votes that is mandated by the bankruptcy code. One of the goals of bankruptcy is to provide debtors with a breathing spell after the commencement of the case. And one aspect of that breathing spell, in addition to the automatic stay that I mentioned, is that only the debtor has the ability to file a Chapter 11 plan and solicit votes on it during the first 120 days of a case. There are circumstances where parties in interest, such as the committee, could seek to terminate or shorten this exclusivity period, at which time, if the court approves that request, other parties can submit their own plan for approval. As I mentioned earlier, confirming a Chapter 11 plan represents the ultimate exit from Chapter 11. Although debtors have the exclusive right to file a plan on their own terms, the plan is generally a product of extensive negotiation between the debtor and key stakeholders, including, and certainly in this case, the committee. The plan process is really broken up into two steps. First, the debtor has to file a disclosure statement, which we'll discuss in just greater detail in just a second. Second, if the court approves the disclosure statement, then the debtor can send out ballots to its creditors seeking a vote in favor of their plan. The disclosure statement that's filed will have the actual plan of reorganization attached to it, but the disclosure statement is a separate document containing additional and different information, and I'll talk about it in a second. Once the plan is sent out for vote, if the debtor receives sufficient votes accepting the plan and the plan complies with the requirements of the bankruptcy code, the plan will be confirmed. Let me turn for a second to the disclosure statement. It is similar to a securities prospectus that a lot of you, I'm sure, have read and labored through in your life. It's designed and it was required to contain adequate information about the debtor's financial affairs to allow creditors to make an informed decision about whether to vote to accept or reject the plan. That disclosure statement will include things such as a description of the history of the debtor, circumstances which in their opinion caused the bankruptcy filing. It'll contain a summary of the Chapter 11 plan of reorganization. It'll contain a description of the nature and value of the debtor's assets. It'll contain a description of the claims and liabilities of the debtor, and how it'll also have to explain, hopefully in plain English, how those claims and liabilities will be treated under the plan. It will usually address potential tax consequences of the plan, and it will also address why they believe what they're proposing in their plan is feasible, meaning simply that they're able to perform under the promises they make in their plan, and any other necessary information to help the creditors make an informed judgment. The first step after they file the disclosure statement describing the plan and all those other things I mentioned, as well as the plan, is the court will hold a hearing on the disclosure statement to decide whether or not it contains adequate information. If the court decides that it does, then the debtor can begin soliciting the plan. And because solicitation of votes cannot happen until there's been a court-approved disclosure statement, that is why at the beginning of these remarks, I made sure to mention to you that this is not a solicitation of a vote for or against the plan, merely a discussion of the status of the case and the status of the plan process. Let me turn now to the plan process, meaning the plan confirmation. To confirm a Chapter 11 plan, at least one class of what are called impaired creditors must vote to accept the plan. An impaired claim is a claim whose rights are being modified. So even if the plan proposes to pay all of you back 100% of what you are owed right now, you will still be deemed an impaired class because, well, let me back up. If the plan provides that you're going to be paid 100 cents on the dollar, but it does so over an extended period of time, in that circumstance, you would be deemed an impaired class because even though you're being paid 100%, you're being stretched out and paid that amount over an extended period of time. And that modifies your rights that you would otherwise have, but for the bankruptcy. The plan must also meet certain requirements under the code. For example, it must be feasible, which means it is not likely that it will be followed after the plan is confirmed by a need to liquidate the company under Chapter 7. The court must find that the plan is proposed in good faith, the plan must also pass what's called the best interest of creditors test, which means creditors will receive under the plan at least as much as they'll get under a Chapter 7 liquidation. And the court has to find that the plan is fair and equitable, and those are terms of art in bankruptcy law. If the plan's confirmed, that those new terms by which Voyager plans to repay its creditors becomes binding on all creditors and all equity holders. Let me now turn to the plan process and Voyager's timeline. As with the sale process that Darren just described, the committee has endeavored to compress Voyager's plan timeline. The reasoning is simple. Confirmation of a Chapter 11 plan is the fastest and most efficient way for creditors, including customers, to receive a distribution, and a faster bankruptcy case means reduced costs. We were able to successfully negotiate a very aggressive plan timeline, which contemplates confirmation of a plan by the end of October. Now, that may seem like a long time, but trust me, in bankruptcy, that is a very, very quick timeline and quick process. And all of us that are involved in bankruptcy law know of far too many cases that take years to resolve. It's important for everyone to understand that the committee's desire for speed in this case does not mean that the committee can ignore everything else and focus solely on speed. We will support a plan only if it's in the best interest of creditors. We're continuing to negotiate the terms of the plan with Voyager so that anyone that goes before the court for acceptance is acceptable to the committee. In the near future, the committee will be sending out a letter to creditors during the solicitation process with our recommendation as to whether to vote to accept or reject the plan. We'll also post this notice on Twitter so that creditors receive the recommendation in real time. Please make sure to share our Twitter page with any creditors that may be impacted by Voyager's bankruptcy. We want to ensure that this information is disseminated as quickly as possible. Darren, I'm going to turn it back to you, or you tell me if it goes to somebody else.
Yeah, I think we're going to go to Michael Cardasco with FTI to provide a high-level financial snapshot of Voyager's financials.
Yeah, thanks, Darren and Chuck. So we put together this financial analysis to give customers a high-level overview of the known assets and claims at the debtor entities. And up front, it's highly preliminary. You'll see there's a number of items which are unknown, and we're working hard to fill in the gaps as soon as possible. We understand that prices can change significantly. Information shown here is as of June 30th, and amounts likely look different today than they did a few weeks ago. But the analysis does provide some directional context, which we think is of value. So at first, the company had operating cash of $104 million. A portion of this cash is going to be used over the next several weeks and months to fund operations during the bankruptcy. Importantly, though, this excludes the cash that's held for customers and FBO accounts. And a couple of weeks ago, the company sought authority to release this cash, which the committee strongly supported. An order was entered by the judge on August 5th, and the company is going to begin accepting withdrawal requests this week. In addition to cash, the company also had a loan portfolio worth over $470 million, and that amount excludes the 3AC loan. In addition, there's $655 million in various crypto assets. Again, these numbers are as of June 30th. So there's a total value of $1.26 billion on this chart. Now that's prior to any value recovered from other items such as 3AC, other cause of action, and any other potential value that could be available for distribution. And the values for these items now are shown as TBD. You can be sure that the company's advisors have been working hard to maximize values for these assets as soon as we retain. That's the value side of the equation. Now we understand that there are estimated customer claims of over $1.8 billion. In addition, there are other there's going to be other unsecured claims. For example, trade, potential contract rejection claims. And these amounts are currently unknown, but they're going to be on top or in addition to the customer claims. And also, not shown on this chart are potential administrative, secured, and priority claims, all of which would need to be satisfied prior to making distributions to unsecured creditors. So again, this is highly preliminary. These numbers will move as we move throughout the case, but this will give customers a good snapshot of where we're at. Let me turn it back to Darren.
Thanks, Mike. And just to be really clear on this slide, if you do the math, it's about $550 million, at least as of June 30th. That's the whole that the company is looking at. Again, these are very preliminary numbers. They're stale numbers. They're about a month and, call it 2 weeks old. But they do probably line up roughly with what we're looking at in terms of the missing amount of money that's not available. Let's go to the next slide. So we are very much focused on returning as much crypto as possible to customers and as quickly as possible. As I said at the outset, and as you heard from Jason, I know that the crypto you transfer to Voyager is your life savings, your wedding fund, your retirement fund, your next mortgage payment. This is not a typical bankruptcy case that is comprised of creditors that are businesses. Most of you are individuals, and for many of you, Voyager was not a small part of your finances. The committee is evaluating all potential options for making an interim distribution to provide creditors with some relief during the bankruptcy process before a plan becomes effective. However, interim distributions to creditors are rare and for the most part unprecedented in bankruptcy. Nonetheless, we think there are compelling circumstances here that justify an interim distribution. But one of the obstacles we face is that the committee cannot ask the court to approve an interim distribution. Only Voyager can make that request. We can't force them to do it. We have had productive discussions with Voyager about making a potential interim distribution, and ultimately we're hopeful that the company will do so. And we, the committee, will continue to do everything we can to effectuate an interim distribution, but we want to caution everyone that there is no guarantee it will happen. And we're also not certain that it can happen on a timeline that is any faster than the planned timeline. Go to the next slide, Greg. Before Voyager filed for bankruptcy, the company formed a special committee of certain directors. Part of the special committee's mandate is to investigate certain actions of insiders, with a particular focus on the loan that Voyager made to 3 Arrows Capital. The special committee has retained a separate law firm to conduct that investigation. But to be clear, the special committee of Voyager that is conducting that investigation, that is a completely separate body from the creditors committee, our client. Ultimately, we expect that the Voyager special committee will produce a report that presents their view on whether insiders are liable for any wrongdoing. It should not surprise any of you to hear that we, the creditors committee, believe preliminarily that there are a number of people and companies that may be liable for wrongdoing and should and will be held accountable. Thus, we are conducting our own investigation of insiders and their potential wrongdoing. We expect that if the Voyager Special Committee concludes there are no claims against insiders, then Voyager will seek to release those insiders from all liability under their Chapter 11 plan. That is what the plan that's currently on file says. If they succeed in doing that, it means that we will not be able to pursue claims that the company has against those insiders. Now, again, the investigation is still underway, so we cannot comment on it. But if we ultimately disagree, if the creditors committee ultimately disagrees with the special committee's conclusions, we will do two things. First, we will recommend to creditors, all of you, to vote to reject any plan that attempts to release insiders so that they do not receive releases. And second, we will object to confirmation of the debtor's plan on the grounds that the releases are improper. So as I said before, it's critical that all of you can continue to monitor the case and look out for recommendations from us regarding the plan. One of the best ways to do that is by attending these town halls. We'll continue to have more of them, and monitoring our Twitter page. For those of you who don't have it yet, our Twitter username is Voyager UCC. I think it's at the bottom of every slide in this presentation. And so please follow us on Twitter and retweet our posts so that others have the same information. So that concludes the first part of the town hall. We are now going to turn to Q&A. We received a lot of questions from you in advance, and we greatly appreciate that. We thought that the best approach was to synthesize the questions for brevity and then select what we view as a representative sampling of the information all of you are asking about. If we don't answer your question today, or if you have follow-up questions, please send an email to the email address that we've set up. It's voyagerucc@epicglobal.com. It's on the Twitter page. It's also on the committee website. And we'll address those additional questions at the next town hall, which we haven't scheduled yet, but I imagine that we'll be having one every 2 to 3 weeks or so. So the first question is, do I need to file a proof of claim and how do I do it? As I said previously, we cannot provide you with individual legal advice regarding your individual circumstances or your individual claim against Voyager. All creditors have unique circumstances, and we encourage you to consult with independent counsel if you have questions. However, we can provide a summary of what the claims bar date order says and generally how the process works. The claims bar date order and the claims bar date notice can be found at docket number 218 on the committee's website under the docket section. Now, these documents will be either mailed or emailed to you, but we encourage you to review them in full and make sure that you understand them. Importantly, the deadline to file a proof of claim in this case is October 3rd of this year, 2022, at 5 p.m. Eastern Standard Time. Prior to August 18th, so in about a week, we expect that Voyager will be filing what are known as the company's schedules. The schedules are supposed to list, among other things, all creditor claims. The debtors will also soon be mailing proof of claim forms to all creditors. For most of you, but not all of you, the proof of claim form that you receive from Voyager will be pre-populated with your contact information, along with what Voyager believes you are owed, whether crypto, cash, or something else. Included with the proof of claim form will be the bar date notice and bar date order. And importantly, the debtors will indicate on your custom proof of claim form whether your claim is scheduled as contingent, unliquidated, or disputed. As set forth in the bar date notice, if you agree with what Voyager included on the pre-populated claim form that you received from them, and your claim is not scheduled as contingent, unliquidated, or disputed, then you may not need to file a claim. Now, if you don't receive a proof of claim form, you should contact the debtor's claims agent, which is Stretto, and request one. We've put there a link to the Stretto website up on this page. And if for whatever reason you decide to file a proof of claim, you must list the amount of each cryptocurrency you're owed in Section 7B of the claim form. And if you have a claim in USD, US dollars, then you will list that amount in Section 7A. The claim forms can be submitted electronically on the Stretto website, or they can be submitted by standard mail. To be clear, they cannot be submitted by email or fax. The easiest way to do it is to go on Stretto's website, but you also can send it in by regular mail. Again, I want to reiterate that this is not legal advice. We are simply providing a summary of what the bar date order says. If you are unsure about whether you should file a claim or how to do it, we strongly recommend that you consider retaining your own counsel to assist with that process. There are two sets of questions that we decided would be best addressed together. This first group on this slide relates to how and when customers will receive a distribution for the amount of crypto or cash that they're owed. And to address these questions, I want to walk through a couple of the potential outcomes that may happen in this bankruptcy case. So as of June 30th, 2022, Voyager held approximately 1.26 billion in value of crypto and crypto loan receivables that were owed by third parties to Voyager. And as of that same date, creditor claims were around $1.81 billion. Voyager also had around $104 million in cash and other assets as of that date. Voyager recently filed a proposed Chapter 11 plan, which I want to summarize briefly. But before I do that, I want to remind everyone that Voyager is running a sale process. The plan that Voyager filed is subject to change significantly, depending on the outcome of the sale process that's going to take place over the next few weeks. I also want to make clear that the committee has a lot of issues with the plan that's on file right now, and we are working through those issues with Voyager and their counsel. So the current plan that's on file provides that all of the company's crypto will be distributed to customers. So it's not as if Voyager or anyone else is proposing that they're going to keep some of your crypto. It's just that they don't have enough crypto to make all the customers whole. The company obviously can't give customers back what they no longer have. So they are proposing to give customers all of the crypto back that they have in their possession. Again, this is under their currently filed plan. Additionally, proceeds from the claim that Voyager has against 3AC would also be used to repay customers. The plan also provides that certain litigation claims will be transferred to the reorganized company to pursue. And the plan contemplates that the company will emerge from bankruptcy as a reorganized company and that the majority of the equity in the reorganized company will be issued to customers. And finally, a portion of the cash remaining would be used to fund a new company that emerges from bankruptcy. So that is what the company has proposed in its plan. The easiest way to think about this plan that's on file right now is that if there were no parties interested in acquiring the company or its assets, this is the plan that Voyager would likely pursue. But as I said before, the company is running a sale process. While we can't discuss the specific indications of interest that have been provided, we can provide a general framework of potential bids that might ultimately be received and what those structures look like. And that's what we put up here on the slide. One potential bid structure is a sale of customer accounts, which would include a transfer of the company's crypto. Many of you have seen the public offer that FTX made. That is the structure we are talking about. Under an FTX-like deal, Voyager would likely cease to exist as a company. Another potential bid structure is where a third party would want to acquire the entire company and continue to operate it as a going concern. Under both of those structures, the buyer is going to pay some form of consideration to Voyager for its assets. And regardless of which form of transaction occurs here, the committee fully expects that the majority, if not all, of the available cryptocurrency held by Voyager will be made available to customers. And that all potential causes of action, whether it's against insiders or others, would be contributed to what is called a liquidation trust controlled by the creditors committee, so that we can recover additional funds to make all of you whole. That is the committee's view. So turning back to the questions, first, how and when do I get my crypto back? In most bankruptcy cases, the earliest point in time when creditors begin to receive an initial distribution on account of their claim is when the plan goes effective. The current timeline in the Voyager case contemplates confirmation of a plan occurring at the end of October. And then there is typically some period of time after that before the plan becomes effective. So at least on the current timeline, the earliest that we would ordinarily be thinking about distributions to creditors, is November. As I mentioned before, we're exploring creative paths to making a distribution much earlier than that, and we'll continue to keep everyone updated on those efforts. But again, I want to caution everyone that bankruptcy cases are fluid, and for a variety of reasons, the timeline can change. The second question, after creditors receive distributions from the assets that Voyager currently has, the crypto that Voyager currently has on hand, is it possible for creditors to be made whole? There are three primary sources of value to make creditors whole in this case. First, any transaction, as I said before, will have a purchase price component to it. This is the amount of money or crypto or some other form of consideration that the buyer will pay to the company for its assets or for the company itself. And although this money does not flow directly to creditors, it flows to the company, and then most, if not all, of that consideration would typically end up being distributed to creditors at some point. Second, if there is a restructuring of any kind where Voyager continues to operate, it is possible that some or all of the equity in the reorganized company will go to customers. So to the extent that creditors receive equity under a plan, that equity could have value. And then third, there will likely be a number of litigation claims to pursue against wrongdoers. If there is a liquidation trust formed in this case, the liquidation trust would pursue that litigation for the benefit of creditors. As and when proceeds from that litigation come into the trust, they would then be distributed to creditors. So those are the three primary sources of recovery for creditors beyond the crypto that Voyager currently holds. The third question, who is investigating directors and officers? As I discussed earlier, the committee is running a parallel investigation to the special committee of Voyager into the acts of directors and officers and other insiders, including affiliates of Voyager. And the committee will do everything in its power to preserve any viable claims against these third parties that could provide an additional source of recovery for creditors. The fourth question that we got from a lot of you is, will Voyager continue to exist after the bankruptcy case concludes? For all the reasons I just discussed, the answer really depends on the outcome of the auction process, and we'll see. We'll know that very shortly in the next few weeks. All right, we can go to the next question. What happens to VGX? This remains an open question that the committee is focused on. We simply don't know yet what the future holds for VGX holders. The sale process and the plan process both need to play out before we can answer that question. The second group of questions that we wanted to address together relate to USD and USDC. As some of you may know, the committee was successful with Voyager in getting the court to enter an order that permits Voyager to allow customers who held USD with Voyager to withdraw those funds from what are known as FBO, or for the benefit of accounts. We understand that Voyager has sent out emails to every customer who is eligible to withdraw funds from the FBO accounts, and those withdrawals should be processed. This was an important early victory for us and many of you, but we obviously have a lot more work to do. To that end, we understand that some creditors are questioning why USD customers are entitled to the return of their cash, while crypto customers must wait. This is because of the way that Voyager structured customer holdings and how the bankruptcy code applies to this structure. When a company files for bankruptcy, the bankruptcy code establishes what constitutes the bankruptcy estate. Assets that the debtor holds in trust for the benefit of another party do not constitute property of the estate. Thus, on the petition date, when Voyager filed for bankruptcy, the funds held in the FBO account were not property of the estate. And that's why the court is now allowing Voyager to return those funds. On the other hand, the way in which Voyager held crypto, whether it's right or wrong, whether they disclose it or not, and it's a separate issue that we are investigating, but the way in which they held crypto compared to cash is not as clear and was different. And let me again be really clear on this. We recognize that many of you were led to believe that the crypto you held on the Voyager platform was your property. Unfortunately, for all of us, that's not the legal test in bankruptcy for determining whether the crypto is your property or property of the bankruptcy estate. What matters are the legal terms that govern the transactions and what the company actually did in practice. This is also the reason why USDC is not being treated the same as USD. USDC is cryptocurrency like all the other crypto, and I know it's a stable coin and that's different, but it is still cryptocurrency, and it was still held by Voyager in the same way that they held other cryptocurrency. Again, this is in contrast to the way that Voyager held USD, which was in a special type of bank account that is held in trust for USD customers. Now, for USD customers that are looking for more information regarding withdrawals, again, Voyager has informed us that emails have been sent out to customers with instructions to withdraw your cash. And there are additional instructions available on our Twitter page. If you need assistance, we would first suggest that you reach out to Voyager customer support. If you are still having an issue, feel free to reach out to us using the committee email address that I mentioned earlier. Again, it's voyagerucc@epicglobal.com. The next question we got from a lot of you is, what is the committee doing about staking? Voyager filed a motion that requested authority to continue its staking practices. The committee had a number of concerns with this, and we negotiated favorable terms that effectively provide the committee with the ability to object to any proposed staking by Voyager of the crypto they currently have on hand. Specifically, Voyager is required to provide us, the committee, with advance notice before making any staking decisions, and we have the opportunity to object before Voyager can move forward with those decisions. We also have a period of time to review all of the company's staking positions that existed as of the date they filed for bankruptcy, and we have the opportunity to object to those positions by going to the court. So that process is well underway on our end. For the next question, how are costs and expenses being reduced? I'm going to turn things back over to Michael Cordasco at FTI.
Yeah, thanks, Darren. So the committee's professionals have been getting under the hood with respect to the company's liquidity needs throughout the case. We've conducted multiple diligence sessions with the debtors' advisors, and we've been assessing the projected short-term cash flow needs of the business. There's more to come here. We're just getting under the hoods now, but we're going to need to. We made it clear to the debt advisor that we need to satisfy ourselves that the company's right sizing the cost structure as soon as possible as part of the bankruptcy. And that work is ongoing.
Thanks. Next question we got from a lot of you is, when will we know who the bidders are? Creditors will not know who all of the bidders are, and we'll learn of who the winning bidder is only until after the auction occurs. As I said at the outset, confidentiality is an important part of the overall bankruptcy process and the sale process in particular. Please know that we have competent professionals representing the committee who are deeply engaged in the process. And the committee members themselves have every incentive, indeed they have a fiduciary obligation to act in the best interests of all creditors. Just as an example, the committee members this week have spoken to several of the interested bidders extensively. That includes both their business and legal teams, and we will continue to be a part of those conversations as the process moves forward. So that concludes our first town hall. I hope this was helpful in understanding what is happening in the case. Once again, our contact information is up on the screen. Please continue to reach out to us with questions or concerns. When we schedule our next town hall in the next couple of weeks, we'll post it on our Twitter page, and we'll attempt to answer all of your questions then.